My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
We are going to continue our class on the children's rights. In this class, we're going to be looking at some of the existing gaps in law, in policies and practice in Nigeria in relation to the observance of child's rights. Okay, so the course objective for this particular module is to create awareness on some of the existing gaps in our in the law regarding children, in the policies, and of course also in practice. Now, at the end of this course, it is expected that you will be able to identify some of the existing gaps in law, in policies, and of course also in practice as it relates to the observance of child rights principles in Nigeria. Now, we're now going to look at some of those gaps that we talked about. Okay, gaps in laws, policies, and practice in Nigeria in relation to observance of child's rights. Now, what are those gaps that we want to look at? The first one, which I mentioned in our last module, is the non-domestication of the Children's Act in most northern states of the country. We have noticed that most of the northern states, have not domesticated this Children's Act of 2003. And remember what we said, that not domesticating that act means that we are now having differentials. While the nationally accepted age for a child is below 18. In some northern states, we have their own laws that has to deal with children, provides for ages that are lesser than 18. Some states have passed and adopted a definition of the child which is not in compliance with that of the convention. And that's what I just mentioned now. That in some states, you have the definition of a child to be maybe 16. In some states, it's even as low as 14. So when we are talking about child marriage, what it means is that a child if someone at the age of 14 or 16 gets married in, let's say, probably in the Northeast, in the eye of the law, according to the law that is at work in that state, it means that there's really no problem with the law. But in the eye of the Children's Right Act of 2003, it means that it is actually not supposed to be so. Another gap we've also noticed is the lack of minimum age for criminal responsibility. We need to have a minimum age where a child can take responsibility for his criminal actions. And this is really very important. Existence of death penalty for persons below 18 under the Sharia law. Now remember when we talked about international laws, we talked about that the international laws which Nigeria is a signatory to expressly prohibits death penalty for children under the age of 18. But of course here in our Sharia laws, we have children under the age of 18, that the law says they can also be subjected to death penalty for their crimes. We're now going to move to look at the gaps in policies. What are some of the gaps we've noticed in policies regarding to children's rights? The first one we're going to look at is the lack of coordination between policies, programs, between national, state, and local levels. And this is really very important. Now remember that we said something about the laws. The lack of coordination means that if in Abuja you have the age of a child being below 18, and let's say probably in Borno, the age of a child is 14, it means that there is a gap a gap in coordination between the national and the state, and this is not supposed to be so. Another gap also is negative impact of the political violence, intercommunal and interreligious unrest, and of armed conflict, of course, in certain parts of Nigeria. Places like the Northeast, where you currently have the war against Boko Haram that is raging, in the North Central, where you have bandits that are, also causing problems, in the Niger Delta, where you have unrest. So communal clashes and interreligious unrest, is one of the things that affects children. Children are the most hit when you have violent conflict. And of course, that's one of the gaps in policy. So there needs to be a specific policy that addresses what happens to children in conflict, the people in IDPs, how are they supposed to be treated, and this is really very important. Now we're now going to look at the gaps in practices. In terms of practicing and implementing this law, what are some of the gaps that we have noticed? Now we're going to look at the first one. Existence of reports that confirms that children have been held in custody in inhuman conditions by the Criminal Investigation Department, the CID, and this is really very important. Remember what we said, that every child has the right to enjoy human dignity, the right to human dignity, very important. But in the course of investigation or in the course of visiting some of the remand home for children, we've seen that children are being subjected to inhuman, degrading, and very cruel conditions. And this is really not supposed to be so. There is also lack of data on the number and nature of complaints of torture on other forms of ill treatment of children deprived of their liberties. When a child is deprived of his or her liberty, there should be a data that says, okay, this is how they are treated. The number of complaints, we don't even have enough data to say, okay, this is really the number of complaints we are getting regarding children in detention, or in terms of torture and ill treatment. We are having a lack of data in that area. And that's one of the gaps we've noticed in implementing the Child Rights Act of 2003. Okay, going forward, there is ill treatment in custody by police, including pretrial detention and other absence of penal procedural rules during their trial before family court. What are we trying to say? We are trying to say that there should be a procedural rule, a rule that you are supposed to follow while dealing with children in custody, while interrogating children during pre-trial, before they go to the family courts. There should be a procedure that says this is the way that children should be treated. There is also imprisonment of children in adult jail, and this is prevalent in Nigeria. You go to some jails and you see children under the age of 18 staying in an adult jail. What do you think will happen? Remember, in one of our models, we said that we have a situation where the strong is oppressing the weak. Now, if you put children in adults, what do you think will happen? The adults will take advantage of the children. And this is really a very big problem that we are not supposed to have. The last one we're going to look at is the penalization of street children for status offenses, vagrancy, truancy, or wandering. There should be a penalty for sending children out to go and be roaming the streets or subjecting children to child labor when it's not supposed to be so. There should be a penalization of street children for status offenses, and that is really very important. Now, it's also been observed that child-specific laws in Nigeria has elaborate provision to ensure that children in conflict with the law or in need of care and protection are treated in a manner that guarantees respect and protection. Okay? Now, there is provision that ensures that children in conflict with the law are treated with respect and are treated with compassion. But the question is, in practice, is this what is really happening? You are in a better position to know as a law enforcement officer. The children in detention, how are they being treated? Are they treated in line with the provision of the Child Rights Act of 2003? However, experience has shown that in the exercise of the statutory powers of the police to arrest, many children are arrested during police raids, and these children are sometimes maltreated. That's exactly what I just said. When you go for raid or you go somewhere, maybe you got a call that something is happening in a particular place, and you swoop in to try to make some arrests. Do you also arrest children? And when children are arrested, are they maltreated? Are they treated fairly? Or are they subjected to inhuman treatment? That is really very important. There are no separation between children in need of care and protection and children identified and arrested for involvement in criminal activities. What we are now trying to say is that there should really be a separation. If you arrest a child who probably participated in a criminal activity, there are children that need special care, maybe mentally deranged children or physically challenged children. They should be treated differently than the way you also treat a child who is involved in a criminal activity and who has no physical or mental challenges. Initial contracts between law enforcement agencies and juvenile offender shall be managed in such a way as it will respect the legal status of the juvenile. What are we trying to say? When you come in contact with a child, the relationship or the interaction should be managed in a way that will respect the legal status of the juvenile, bearing in mind that that is still a child. So you need to bear that in mind. When you come in contact with a child, you must understand that this is a child first of all, and the way you deal with that child must be different. You must promote the well-being of the juvenile and avoid harm to him or her with due regard to the circumstances of the case. When you come in contact with a child, you must treat that child with respect differently from the way you treat an adult. There is no law which specifically provided for the way and manner which children should be arrested. Article 35 of the United Nations Convention on the Rights of the Child provides that the arrest should be carried out in conformity with the law. Now, the Child Rights Act doesn't provide expressly how a child should be arrested. But what we are trying to say is that according to Article 5 of the United Nations Convention on the Children's Rights, you need to be able to adopt that in dealing with children in the absence of our own national laws. Now, the Postal Institution and Remand Centers, the Postal Institutions and Remand Centers Act, Cap B11, Laws of Federation of Nigeria 2014, made some provisions. These are laws relating to children and juvenile. Now, apart from the Child Rights Act, there are other acts, other principles, other regulations that also tells us how we should relate with children. And we're just going to list out some of them. I just mentioned one earlier. There is Child Rights Act, there is Children and Young Persons Act, Cap 32, Laws of the Federation of Nigeria, that came into existence as far back as 1958. There is the Children and Young Persons Law, Cap 21, Laws of Northern Nigeria, which is in effect in Northern Nigeria, and it came into into enforcement in 1963. There is the Criminal Procedure Act, Cap 38, Laws of the Federation of Nigeria. It came into effect in 2004. The Criminal Procedure Act, Cap 30, Laws of Northern Nigeria in 1963. There's the Police Act, Cap 19, Laws of the Federation of Nigeria. And of course, there is the Penal Law, Cap 89, Laws of Northern Nigeria, 1963. All of these laws has to do with children, and of course it's also advised that you keep yourself abreast with some of these laws so that you understand fully, holistically, how you're supposed to deal with children. Now we're now going to look at some conventions that has to do with the children's rights, apart from the laws we just mentioned now. There's the African Union Charter on the Welfare and Rights of the Child, 1990. And I must stress this, that all of these conventions that I'm going to list out now, Nigeria is a signatory to the treaties that brought these conventions into force. The United Nations Convention on the Child Rights came into effect in 1989. United Nations Standard Minimum Rules for the Administration of Juvenile Justice, United Nations Guidelines for the Prevention of Juvenile Delinquency, that we call the Riyadh Guideline. And if you remember, we also dealt with Riyadh Guideline when we were discussing human rights in the Nigerian police. And lastly, the African Charter on the Rights and Welfare of the Child, and that came into effect in 2001. Now, the role of the National Human Rights Commission, remember we also dealt with National Human Rights Commission when we were talking about international and national organizations that you have to work with while dealing with children's rights. Now, the role of the national human rights institutions is to monitor independently the state's compliance and progress, thorough implementation, and ensure full respect for human rights. Now, this is also part of the work expected from the NHRC, the National Human Rights Commission. Part of their duty also is to look at what you are doing to ensure that what you are doing is in compliance with provided laws. Now, the Article 12 of the Convention, as already emphasized, requires due weight to be given to children's views in all matters affecting them, which plainly includes implementation of their convention. Okay? The state needs to work closely with NGOs like PRAWA while respecting their autonomy. This includes, for example, human rights organizations, child and youth-led organizations, youth groups, parents, families, faith-based organizations, academic institutions, professional associations. Remember, we always say that policing is a collective responsibility. The work you really do is very important, and you cannot do it alone. So you need the partnership and the support of non-governmental organizations, private organizations, to be able to fully discharge your responsibilities. And we are hoping that you will be able to access some of this help with private organizations to ensure that we all together as a nation protect and promote the rights of children in Nigeria. Thank you very much for listening.